So juror number 13, that's you. Juror number 15 is in the back corner, correct? I don't want to use names. Juror number 40, I'm sorry, juror number 30 is in the seat. You're in the correct seat. And juror number 34, juror number 40 at the bottom in the end, and juror number 38, that's you? Okay. And across the top, we have 14, 16, 3, 4, 5, 23, 29, 28, 28, I'm sorry, 8, 26, 21, 13, wait, 13, and 24. So is everybody in the right seat? Okay, you got it right the first time. Okay, well, thank you very much. Thank you all for being here. Hope you had a nice long weekend. I'm sorry we got started just a few minutes late. We had a couple things we had to finish up before going on the record. I'm going to pre-instruct you on the law right now, and then we're going to take a short recess so we can get set up for opening statements. But we want to make sure the attorneys have enough time to get everything ready to go and make sure everything's working fine. So I'm going to pre-instruct you on the law that you are to follow in the case, and then we're going to take a short recess and go right into opening statements. So, ladies and gentlemen of the jury, before we hear the opening statements of counsel and begin to take evidence, I will read to you some preliminary instructions to follow in listening to and considering the evidence, which you will hear in this case. I will also give you some further instructions after you've heard all the evidence that covers additional law which you are to follow. It is my duty to instruct you in the law, and it is your duty to follow the law as I stated to you both now and at the conclusion of trial. At the conclusion of trial, I'm going to give you a notebook that has all the jury instructions that you are to follow. It will give you all the law that you need to reach a verdict in this case if you can. It is your exclusive duty to decide all questions of facts submitted to you and apply the law which I give you to the facts as you find them. You must decide the facts from the evidence received in this trial and not from any other source. That's why I've told you time and time again, you can't read the paper, you can't watch any news accounts about this trial, or listen to anything anybody says to you, because you have to decide this case based on what you receive here in trial. You must determine the effect and the value of the evidence. You must not be influenced in your decision by mere sentiment, conjecture, sympathy, passion, or prejudice towards any party, witness, or attorney in this case, or public feeling or public opinion. If I repeat any principle, instruction, or idea, or state it in varying ways, no emphasis is intended by me, and none should be inferred by you. All of the court's instructions, whether given before, during, or after the taking of testimony, are of equal importance. Now, the attorneys for the parties, of course, will take very active roles in the trial. This may include making opening statements to you, questioning witnesses, making objections, and then finally, arguing the case to you at the conclusion of the evidence. Remember that attorneys are not witnesses. Since it is your duty to decide the case based solely on the evidence which you see or hear in this case, you must not consider as evidence any statement the attorneys make during the course of the trial. Now, like most things, there are exceptions. First, if the attorneys agree to any fact or stipulate to a certain fact, then you must accept that fact as being true. And if they do reach stipulations, we will write it out for you, and that will go back into the jury room. The only other exception is if an attorney takes the oath as a witness and sits in this witness stand right here and testifies from the witness stand. Then you can give that attorney witness's testimony as much weight as you've seen that it's entitled to. Now, in over 30 years of being in the legal profession, I have never seen that happen. But the only reason I tell you about that is if these attorneys are making opening statements to you and they say something like, the light was green, all right, that's not testimony because they are not sworn witnesses. So you cannot consider anything that the attorneys say as evidence. Now, after the opening statements, the people will first offer their evidence. Evidence usually includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but they are not required to do so. Because he is presumed innocent, the defendant does not have to prove that he is not guilty. It is the people's burden alone to prove that the defendant is guilty. Now, after you've heard all the evidence and before the attorneys give their final arguments, I will again instruct you on the law that applies to this case. After you hear the arguments and instructions, you will then go to the jury room to deliberate. As jurors, you must decide what the facts are in this case. You must use only the evidence that is presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. We have rules of evidence that have been developed over the years which will guide us in the conduct of the trial. Generally, you may not fully understand why we have these rules, but I assure you there are good reasons for them, even if those reasons are not apparent to you. Now, during the course of the trial, an attorney may make an objection to the introduction of testimony. He or she, in effect, is saying that in his or her opinion, the offered testimony is not permitted by the rules of evidence. I'm sure you've seen this before, but when there's an objection is made, the court can either sustain the objection or overrule the objection. When I sustain an objection, the witness will not be permitted to answer the question. You must not guess why I have sustained the objection, and you may not speculate as to what the answer might have been. Now, when I overrule an objection and the evidence is permitted, that does not express any opinion as to how you should treat such evidence. All that ruling says is you have a right to hear such evidence. But you, as jurors, may completely reject such evidence if you feel it's appropriate to do so. You may give it very little weight, or you may give it a great deal of weight. That is your responsibility as jurors because you are the judges of the facts. If any answer is given to a question and the court then grants a motion to strike out the answer, you are then to completely disregard the answer and you must not consider it for any purpose. Just treat it as though you never heard it. You should keep in mind that a question in and of itself is not evidence. It may be considered by you only as it helps you to understand the answer to the question. Do not assume to be true any insinuation suggested by a question that is asked of a witness. You must disregard anything you see or hear when the court is not in session, even if it is done or said by one of the parties or one of the witnesses. No statement, ruling, remark, or comment which I may make during the course of the trial is intended to indicate any opinion I may have as to how the jury should decide the case or to influence the jury in any way in its determination of the facts. Now, at times I may ask questions of the witnesses. If I do so, it's for the purpose of bringing out matters that I feel should be clarified and not in any way to indicate the weight I feel the jury should give to the testimony of any witness. As I stated earlier and last week, it is the defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove each element of a crime and allegation beyond a reasonable doubt. Now, whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that is received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal and you must find him not guilty. Now, any fact in this case may be proved by either direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. Circumstantial evidence sometimes is also referred to as indirect evidence. Now, I'm going to define circumstantial evidence to you. Keep in mind that this definition was written by a bunch of judges and lawyers, so I'm going to read it to you and see if you can follow it. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. So does that clear it up for you? Let me give you an example. Let's say the only issue in this case is whether or not the defendant was in a swimming pool in someone's backyard. And we have a witness that comes in here and testifies on the stand under oath that I saw the defendant in the swimming pool. That is direct evidence as the ultimate fact that you have to decide. Now let's change it a little bit and let's say a witness comes in and under oath says, I never saw the defendant in a swimming pool, but I went into the backyard. The water was choppy and churned up as if somebody was just swimming in the pool. There was nobody else around, and there were wet footprints leading up to the defendant who was standing there soaking wet in a bathing suit. That is circumstantial evidence that the defendant was in the pool. So it's a group of facts from which you can conclude that the defendant was in the pool. So with that said, I'll reread that definition to you. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. Now, both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact at issue has been proved based on all the evidence. Now, as jurors, you have the exclusive duty to decide the credibility of the witnesses who will testify in this case, which means that it is you who must decide whether to believe or disbelieve a particular witness and how much weight, if any, to give the testimony of each of the witnesses. The testimony of each witness must be judged by the same standard. You must set aside any bias or prejudice you may have, including any based on the witness's gender, race, religion, or national origin. In deciding whether testimony is true and accurate, use your common sense and your experience. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and then decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony, including but not limited to the following factors: the extent of the opportunity or the ability of the witness to see or hear or otherwise perceive the things about which the witness has testified, the ability of the witness to remember or to describe what happened, the witness's behavior while testifying here in court, whether the witness understood the questions and then answered them directly, the existence or non-existence of a bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in the outcome of the case, the attitude or demeanor of the witness about the case or about testifying, whether the witness made a statement in the past that is consistent or inconsistent with his or her testimony, and finally, the reasonableness of the witness's testimony when considered in light of all the other evidence in the case. Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the very same event, yet see it or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but then told the truth about others, you may simply accept the part that you think is true and then ignore the rest. Now, both the people and the defense are entitled to the individual opinion of each juror. That means that each of you, for yourself, must determine the factual issues to be resolved in this case. Some words or phrases that may be used during a trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in the instructions that I give you. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in the instructions are to be applied using their ordinary everyday meanings. Please keep an open mind throughout the trial. Do not make up your minds about the verdict or any issue until after you've discussed the case with any other jurors during deliberations. Do not take anything I say or do during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. Now, after the opening statements, we're going to hand out some notebooks for everybody. We have notebooks and pens for all the jurors and all the alternates, and they are numbered jurors 1 through 12 and then alternates 1 through 4. And as a side note, for the alternates, although you may be labeled as alternates 1, 2, 3, and 4, if we have to seat one of the alternate jurors during the course of the trial, we put all 4 of your names in a hat and pull out one name so you all have an equal shot at serving on this jury if one of the other jurors is unable to fulfill their obligations. Now, I do not give you the notebooks during opening statements because, as I told you, what the attorneys say during their opening statements is not evidence. Once you have the notebooks, you cannot remove the notebooks from the courtroom. At each recess, I'll ask you to leave the notebooks on your chairs. You cannot take the notebooks home with you. You will be able, obviously, to take the notebooks into the jury room with you when you deliberate. You may use your notes during deliberations only to remind yourself of what happened during the trial. Keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement during the deliberations about what actually happened at trial, you can ask that the court reporter's record be read back to you for the testimony of any particular witness you are interested in hearing. Do not let your note-taking distract you from your ongoing responsibility to evaluate the witnesses and the evidence. I also expect that police reports will be mentioned at some point in time during the course of the trial. It is proper for the attorneys and the witnesses to refer to police reports during the trial. Sometimes the attorneys might ask a witness to refer to a police report to refresh their memory as to what was said during their interview with the police. However, the written police reports themselves are not evidence for a number of legal and evidentiary reasons, and therefore you will not be receiving the written reports or copies of them as evidence back in the jury room. And I tell you this now because if I don't, the first note you send back will say, can we have all the copies of the police reports? The answer will be no. There's a Supreme Court decision case that says they don't go back into the jury room, and I tend to follow what the Supreme Court says. So you will not be getting the police reports back into the jury room. However, if it appears to you there's some reference in a police report that is important to your understanding of the facts, you can simply jot it down in your notes and refresh your memory later. You will now be admonished and continually admonished during the course of the trial that it is your duty not to converse among yourselves or with anyone else on any subject connected with this case. During the trial, do not talk about the case or about any people or subject involved in the case with anyone, not even your family, friends, spiritual advisors, or therapists. Do not share information about the case in writing, by email, on the internet, by any other means of communication or social media. Don't put anything on Facebook, Twitter, Instagram, anything. You must not talk about this case with the other jurors either until the time comes for you to begin your deliberations. Now, some of you may become quite friendly during the course of trial, and a couple of you might go out for lunch together. You still cannot talk about the trial with each other. You can't talk about the case with anybody until you're back in the jury room at the conclusion of the trial. As jurors, you may discuss the case together only after all the evidence has been presented, the attorneys have completed their arguments, and I've instructed you on the law. After I tell you to begin your deliberations, you may discuss the case only in the jury room and only when all jurors are present. So, counsel, may it be stipulated that the jurors may be deemed to have been so admonished pursuant to Penal Code Section 1122 at each adjournment, whether or not the admonition is read in full. Mr. Owens? All right. So what does that mean? That means whenever we take a break, I don't have to read this 3-page admonition to you every time we leave the courtroom. What I will say is, please remember the admonition, and that's the admonition I'm referring to. You must not allow anything that happens outside of the courtroom to affect your decision. During a trial, do not read, listen to, or watch any news report or commentary about this case from any source. You are not to form or express any opinion of this case until the case has finally been submitted to you. Do not do any research or investigation on your own or as a group. Do not Google anything about this case. Do not Google Mr. Winslow's name. Do not do any research whatsoever. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop and investigate. Now, if you have a cell phone or other electronic device, please keep it turned off while you're in the courtroom and during jury deliberations. An electronic device also includes any data storage device. If someone needs to contact you in an emergency, the court can receive messages that it will deliver to you without delay. And if you need to give that number that we gave you last week to anybody who needs to contact you during the trial, they can call and we will immediately deliver that message to you. But we'll have breaks routinely throughout the trial, and you can check your messages during a recess. Now, during the trial, it may be necessary for the court and counsel to meet outside the presence of the jury, either in chambers, at sidebar, or by asking to leave the courtroom. You should not speculate on these proceedings at all, because they only concern legal issues upon which the court must rule before the trial may proceed. As I mentioned last week, during a trial, you may see the attorneys in the elevators or walking down the hallway. You may even see some witnesses wandering around the hallway. Please do not think anybody's being rude or unfriendly when they won't talk to you. You are directed to have absolutely no conversation whatsoever of any kind with any party, attorney, or witness in this case during the course of the trial. Likewise, the attorneys, parties, and witnesses are also directed not to speak to any juror during the case during the course of the trial. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. If someone asks you about the case, just tell him or her that you cannot discuss it. If that person keeps talking to you about the case, you must end the conversation immediately. If you receive any information about this case from any source outside of the trial, even if it's unintentional, do not share that information with any other juror. If you do receive such information, or if any person attempts to improperly influence you or any member of the jury in any way, you must promptly report such attempts immediately to the court. You can just let Manny know that you need to talk to the judge, and we can talk to you and find out exactly what happened. Do not let bias, sympathy, prejudice, or public opinion influence your decision in any way. And finally, you must reach your verdict without any consideration whatsoever of punishment. So that's the pre-instruction I read to you. I wanted to break it up just a little bit because I didn't want to go straight from 10 to 12, so we're going to take a break right now. We'll take 15 minutes, and when we come back, we'll hear both opening statements, and then we'll start taking testimony shortly thereafter. So please remember the admonition: don't discuss the case with anybody or form or express any opinion. Why don't we say we'll be back here right at 10:45. 10:45, and we'll begin with the opening statements. All right? Thank you very much. And can I see counsel at sidebar while they're leaving?